Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the additional rules framed by the Honorable Supreme Court of India in giving designation of senior advocates according to Section 16, Clause 2 of the Advocates Act 1961. For the ethics students, I have told you, according to Section 16 of the Advocates Act 1961, there are only two types of advocate, two classes of advocates, senior advocates and advocates, that's all, no junior advocate. But still, in common parlance, we use the word junior advocates. Right? To become a senior advocate, certain criteria is necessary, and previously, as per Section 16, the senior designation will be given after his consent. So the senior advocate, the advocate should give his consent to be designated as senior advocate. Of course, it doesn't depend on the age. It depends on the 5-point formula, like 5-point formula, because a lot of controversies arose while designating the advocates as senior advocates. And you know, the advantage is that he need not file wakalat. He can straight away go to the court along with the advocate on record and submit his arguments, and he will be given pre-audience also. This all you must know. And in this connection, in the year 2015, Indira Jaising, Madam Indira Jaising, she filed a case that there are some irregularities in designating the senior advocates. So, in that writ petition, that is 454 by 2015, so that has been continued. Once again, that has surfaced. You can read the case as Indira Jaising versus Supreme Court of India in presently in MA number 709 by 2022 relating to WPA Civil number 454 by 2015 and three judges bench, Justice Sanjay Kishan Kaul, Ahsanuddin, Amanullah and Arvind Kumar on 12/5/2023 opined that, please remember, though doing away with the category of publications would not be wise, it should be expected to teaching assignments. So what are the previous criteria? Better to know. Previous criteria is number 1, standing in the bar. Number 2, ability. Number 3, experience. Number 4, the pro bono cases committed by him. Number of judgments in which he was involved. That means his cases, how they fared. And lastly, publications of articles to the law journals. Here the problem came. As regards the publication of law journals, it's very difficult for a practicing lawyer to find time to write journals to the. Suppose why I am making articles, the videos is because I am free. Suppose if I am a regular practitioner of law, can I find time to make a 5 minutes video? I have to read the judgment for half an hour. Then only I can minimize the same, because we can't tell all these things. So it has become practically difficult for the people to write the articles in the journals, and the journal should publish the same, and basing on that he will get marks. This is not wise. So once again, Indira Jaising judgment stated that it is difficult for the advocates and it is not wise to base the points on the so-called publishing of journals. Instead of it, now another point has come. They can go to the colleges, they can take up the teaching assignments. So Actually, Indira Jaising, she argued that a candidate to be designated for senior advocate is duty bound. This candidate is particularly duty bound to contribute the public life and publish the teaching of the law to the students is one way of the same. But Vikas Singh, Advocate, Supreme Court Bar Association, he said that the publication of articles may be removed. And of course, the bench also stated that senior advocates are advised to contribute to the teaching, writing and research. These three fields one has to excel to become a senior advocate. Most practicing advocates, of course, they find little time to write academic publications. So this is all we know. But as academician, as advocate, better to go for research also. You see the case of Justice Dr. K. Manmadh Rao of Prakasham district, who did his PhD as an advocate under Sri Rajendra Prasad Gar of Vizag University, Amara University. So likewise, our principal sir, Nataraj Kumar, he did his PhD. Allah Haribabu is doing is pursuing the PhD like that. Says definitely they will get that senior designation basing on this. So please remember, the publishing of journals may be waived, and the teaching and then teaching, writing and research, they may be included for getting the senior designation. Let us see. And another point is the so-called designation. Legal profession should not be a family profession. Newcomers also should be encouraged. Therefore, the limit of 45 years, it cannot be continued. Younger advocates, yes, there are so intelligent people. They can be designated the senior advocacy because if they have got the so-called extraordinary merit or intelligence or experience or the profound knowledge in a particular topic, so they should not be precluded from the so-called designation. This is what the Honorable Supreme Court of India opined in this particular case. So Indira Jaising case has once again resurfaced. Please read it and enrich your legal knowledge regarding the designation of senior advocates as per section 16 of the Advocates Act 1961. With this, I am concluding. Thank you very much.